My ex-husband filed a lawsuit demanding half of my $18 million inheritance. He laughed. "You will lose." I just smiled and said, "Good luck." When my lawyer pulled out one document, my ex-husband went silent. "Good day, dear listeners. It's Maria again. I'm glad you're here with me. Please subscribe to my channel and like this video. And also, let me know in the comments which city you're listening from. That way I can see how far my story has traveled. I used to believe that a good marriage was built on trust. Quiet, unshakable, almost invisible trust. The kind you never think about because it's simply there, like oxygen. For 11 years, I believed I had that with Daniel. My name is Claire Harrison Morrison, and this is the story of how my ex-husband tried to take half of my $18 million inheritance, and how a single document left him speechless in a courtroom in downtown Chicago. But let me start at the beginning. Before everything fell apart, my life looked like something from a catalog. We lived in a 4-bedroom house in Oak Park, a leafy suburb west of Chicago. I worked as a senior architect at a mid-sized firm on Michigan Avenue. Daniel ran a small but profitable consulting business from a glass-walled office in the Loop. We had date nights on Fridays, vacations in August, and Sunday mornings that smelled like coffee and fresh newspaper. We were, by all visible measures, fine. My father, Robert Harrison, died in March of that year. He was 71, sharp until the last week, and he left behind a carefully constructed estate, the result of 40 years building a regional logistics company from a 2-truck operation into a fleet that served 8 states. His will distributed his assets among my mother, who had predeceased him by 6 years, my younger brother Todd, and me. My share came to just under $18 million, held in a trust my father had established years before his death. I remember sitting in the attorney's office in Naperville, listening to the trust officer explain the details and feeling 2 things simultaneously: grief so heavy it pressed against my ribs, and a strange, uncomfortable awareness that the number being discussed was enormous. I had known my father was comfortable. I had not known exactly how comfortable. Daniel sat beside me at that meeting, holding my hand. He squeezed it at the right moments. He said the right things afterward in the parking lot. "Your dad built something incredible, Claire. You should be proud of him." I cried, and he held me, and I told myself that whatever came next, at least I wasn't facing it alone. I was wrong about that, but I didn't know it yet. The first sign came about 6 weeks after the funeral. It was subtle enough that I almost dismissed it. Daniel had always been the one who managed our household accounts, not because I couldn't, but because he'd set it up early in our marriage and it had simply stayed that way. I noticed, while looking for a restaurant receipt for an expense report, that our joint savings account had a transfer I didn't recognize. $42,000, moved to an account I didn't have the routing number for. When I asked Daniel about it, he said it was a short-term business bridge loan he'd arranged with a private lender. Nothing to worry about, he'd explain the details later. His phone was ringing. He never explained the details. I told myself it was stress. He was under pressure. His biggest client had just shifted 40% of their contract to a competitor. I understood. I let it go. The second sign came 3 months later, at a dinner party at the Kellerman's house in Wilmette. Sarah Kellerman and I had been friends since graduate school. It was a casual Saturday evening. 6 couples, good wine, the kind of conversation that wanders pleasantly without landing anywhere important. Near the end of the night, Sarah pulled me aside while the men were arguing about baseball in the kitchen. "I probably shouldn't say anything," she said. She had the look of someone who has been debating with herself for some time. "Then don't," I said, though something cold had already started moving through my chest. I saw Daniel at Spiaggia last Tuesday. Lunch. With a woman I didn't recognize." She paused. They weren't eating much. They were talking very quietly, very close together. I thanked her. I said Daniel had a lot of client meetings. I excused myself to find my husband, and when I found him, I watched his face for 5 seconds without speaking, and he smiled at me with the easy confidence of a man who doesn't think he's been caught. I smiled back. That was the first real moment I understood something was wrong, not just with our finances, not just with Tuesday lunches, but with the entire architecture of my marriage. The legal summons arrived on a Wednesday morning in November, 11 months after my father's funeral. A process server knocked on my office door at 10:45. My assistant showed him in with an apologetic look. He handed me an envelope and left. Daniel was suing me for half of my inheritance. I read the document twice, standing at my desk, the city spread out behind me through the floor-to-ceiling windows. Then I set it down, walked to the window, and looked out at Michigan Avenue for a long moment. That evening, Daniel called me. He'd moved out 2 months earlier, ostensibly to give us space. His voice on the phone was smooth, almost cheerful. "You saw the filing," he said. "I did." "Claire, listen. I have a strong case. You should know that. My attorneys are confident." A pause. Then lightly, "You're going to lose this one." I looked at the summons on my kitchen counter. I thought about my father, 40 years, 2 trucks, 8 states. I thought about the trust document sitting in my attorney's files. And then I said the only thing I felt in that moment. "Good luck, Daniel." He laughed. He actually laughed. He had no idea what was waiting for him. I didn't sleep that night. I sat at my kitchen table in Oak Park with the legal summons, a yellow legal pad, and a cold cup of tea, and I made myself read every page of Daniel's filing carefully. He was claiming that my inheritance, all $18 million of it, constituted a marital asset subject to equitable distribution under Illinois law. His argument rested on 2 pillars. First, that I had commingled the inherited funds with our marital estate. Second, that he had made substantial contributions to the marriage that allowed me to manage and grow that inheritance, and that to deny him a share would be unjust enrichment. $9 million. He wanted $9 million. I set the document down and pressed my hands flat against the table. The kitchen was very quiet. The refrigerator hummed. Outside, a car moved slowly down the street. I noticed, with a strange detachment, that my hands were not shaking. That surprised me. I had expected fear to feel like trembling. Instead, it felt like cold water rising slowly around my ankles, steady and very, very clear. Was he right? Could he actually win this? I forced myself to think through the facts methodically. Illinois is an equitable distribution state, not a community property state, meaning inherited assets are generally considered separate property, not subject to division in divorce. But generally is a dangerous word in a courtroom. The exception that Daniel's attorneys were likely targeting was commingling. If I had mixed inherited funds with marital funds, a court could potentially reclassify all or part of the inheritance as marital property. Had I commingled it? I went through the timeline in my mind. My father had established the trust before his death. The inheritance had been transferred directly into the trust upon his passing. The trust held the assets in a separate account at a private wealth management firm in Naperville. An account solely in my name as the named beneficiary, with no joint access. I had never transferred money from that trust into our joint accounts. I had never used trust assets to pay a mortgage, a vacation, a car payment. The trust had been managed as a completely separate financial instrument. But Daniel's attorneys were smart. They would argue perception, contribution, lifestyle. They would argue that by maintaining the marriage, Daniel had freed me from financial anxiety and allowed me to focus on managing the inheritance. They would make the math sound fair to a judge who might not understand trust law the way a specialist would. By 2 a.m, I had filled 6 pages of the legal pad with notes. What I needed was not just any divorce attorney. I needed someone who specialized in high-asset divorce with a specific focus on inherited property and trust law. I also needed to understand exactly what Daniel had been doing with our marital finances for the past 2 years. Because the $42,000 transfer I'd seen in the joint account wasn't the only irregularity. Sitting at that table, forcing myself to reconstruct the financial picture of our marriage from memory, I began to count. The unexplained transfer, the sudden bridge loan he'd never explained, the consulting business that had been struggling, yet somehow Daniel had bought a new car last spring, a $68,000 lease he'd brushed off as a business necessity, the 3-week client trip to Phoenix in September that I now, in the cold clarity of 2 a.m., was no longer sure had been a client trip at all. I picked up my pen and wrote 3 words at the top of the legal pad. What did he take? The next morning, I called Margaret Chen. I had met Meg Chen at a fundraiser 2 years earlier. She was a partner at Harrington & Cole, one of Chicago's most respected family law firms, and a friend of a friend. She was 47, precise, and had a reputation for being the kind of attorney who prepared so thoroughly that opposing counsel often settled before reaching trial. She'd won a landmark inherited asset case in the Seventh Circuit that was still cited in Illinois family law briefs. She had availability at 11. I sat across from her in a corner office on the 34th floor of a building on LaSalle Street, with Lake Michigan visible as a gray line in the distance. I put the summons on her desk. I put my legal pad beside it. I told her everything: the trust structure, the timeline of the inheritance, the financial irregularities I'd noticed, the Tuesday lunch at Spiaggia, the phone call where Daniel had laughed and told me I would lose. Meg read through the summons without any visible expression. Then she set it aside and looked at me. "He's gambling," she said. "His attorneys know this is a long shot on the inheritance. Illinois law is fairly clear on separate property. But if they can establish even partial commingling or make a strong enough equitable argument, they might get a judge to award him something." She folded her hands. "The question is whether his attorneys have something you don't know about." "What would that be?" "A transaction. A transfer. Something that ties the trust assets to the marital estate, even tangentially." She paused. "Did you ever, for any reason, move money from the trust into a joint account, even temporarily, even to float a household expense?" I thought carefully. "No, never." She nodded slowly. "Then the first thing we need is a complete forensic accounting of both the trust and your marital finances going back to the date of your father's death. Everything, every account, every transfer." She glanced at the notes I'd written about the $42,000. "And I'd like to understand a great deal more about where your marital assets have been going." She said it quietly, without drama. But I felt the words land with weight, because I realized, sitting in that office with the lake gray and flat in the distance, that I had been asking the wrong question. I had been asking whether Daniel could take my inheritance. The real question, the one Meg was now raising, was what Daniel had already taken. I left her office with a retainer agreement, a list of documents to gather, and the first clear outline of a plan forming in my mind. I would need to be methodical. I would need to be patient. I would need to document everything without alerting Daniel that I was doing so, and I would need to stop being afraid of him. He had laughed. He had actually laughed at me on the phone. That laugh stayed with me on the elevator ride down, through the lobby, out onto LaSalle Street in the November cold. It followed me all the way home. I decided, somewhere between the parking garage and my front door, that it would be the last time Daniel Morrison laughed at my expense. The forensic accountant Meg brought in was a quiet, meticulous man named Gerald Park, who had spent 12 years with the IRS before going into private practice. He wore the same style of gray cardigan every time I saw him, spoke in complete sentences with no wasted words, and had the unhurried patience of someone who understood that financial dishonesty almost always left a trail. You simply had to follow it far enough. We met in Meg's conference room on a Thursday afternoon in late November. Gerald spread a series of spreadsheets across the table with the calm of a surgeon laying out instruments, and we began. The marital finances told a story I had not been ready to read. Between the month my father died and the filing of the divorce summons, a period of roughly 11 months, Daniel had moved $214,000 out of accounts to which he had access. Some of it had gone to the private lender account I'd spotted. Some had been routed through his consulting business as operating expenses. $14,000 had been charged to a business credit card I hadn't known existed, against a billing address in Lincoln Park. Not our house in Oak Park, not his office in the Loop, Lincoln Park, the same neighborhood where the woman at Spiaggia presumably lived. I sat with that number for a moment. $214,000. It was not, in the context of an $18 million inheritance, a staggering sum, but it was our money, the savings and equity we had built together across 11 years of a shared life, and he had moved it quietly, methodically, while attending dinner parties and squeezing my hand at the attorney's office and assuring me everything would be fine. Gerald looked up from his spreadsheet. "I want to be clear about what this does and doesn't prove," he said. "This establishes a pattern of financial transfers from joint marital accounts. It does not, on its own, constitute fraud or dissipation in the legal sense, but it is a very useful foundation for a dissipation claim, specifically that marital assets were spent on a relationship outside the marriage. Which means a court could order those funds returned to the marital estate before division, reducing what he walks away with, and depending on how the judge views it, it may affect credibility in the broader case." He removed his glasses and cleaned them slowly. It also tells us something about his strategy. He moved money knowing the divorce was coming. He was not careless. He was deliberate. I drove home from LaSalle Street in the dark, through the tunnel of lights on the Eisenhower, and I thought about deliberateness, about the 11 years I'd spent trusting a man who had been quietly and carefully planning an exit long before I was allowed to know one was coming. The response from Daniel's side came faster than I expected. 2 weeks after we engaged Gerald Park, I received a call from Daniel's attorney, a man named Broderick Walsh, whose firm had an aggressively modern website and a reputation for high-conflict divorce litigation. Walsh was polite in the way that is specifically designed to feel like a warning. "Ms. Harrison," he said, pointedly not using Morrison, "I understand you've retained Margaret Chen, a solid choice. I also understand you've begun a financial review." A pause. "We want you to know that we welcome full financial transparency. We have nothing to hide." I said nothing. "We do want to flag," he continued, that our client has documented several instances in which he contributed to managing and preserving the inherited assets during the marriage. Conversations with your father's trust officer, introductions to investment advisors, time and expertise that have a measurable value. We'll be presenting that case fully. After I hung up, I told Meg. She was quiet for a moment. "They've been watching what we're doing," she said. "Walsh doesn't make courtesy calls." She leaned forward. "They're worried." Good. The document arrived on a Tuesday. Gerald Park called me at 8:15 in the morning, before I'd left for the office, and asked me to come in as soon as possible. I canceled a 9 o'clock meeting and was at Meg's office by 9:30. Gerald had the printout on the table. He placed it in front of me without preamble. It was a communication, an email chain, obtained through the formal discovery process we had initiated between Daniel and Broderick Walsh, dated 4 months before Daniel had filed the divorce summons. In it, Daniel outlined in considerable detail a strategy for the divorce proceedings. He described the inheritance. He described my father's trust. And he wrote in a sentence that I read 3 times to make sure I had understood it correctly. If we can argue commingling through the household renovation account, the Marigold account, and the Naperville meeting in 22, we may be able to muddy the waters enough to get a settlement. She'll settle rather than go through discovery. He had been planning this for at least 4 months before he filed. He had mapped it out. And he had been wrong about one thing, catastrophically, decisively wrong. He had been sure I would settle rather than fight. I sat with that email in my hands for a long time. The office was quiet. From somewhere down the hall, I could hear the faint sound of a coffee machine. I looked up at Meg. "He mentions 3 things," I said. "A household renovation account, the Marigold account, a Naperville meeting in 22.8. She nodded. "We need to run all 3 down, every document, every transaction, every record from that meeting." She held my gaze. "Claire, I want you to understand, if he manufactured evidence to support a commingling argument, that changes this case entirely. That's not a civil dispute anymore. That has implications." The Marigold account. I had never heard that name before. I had no account called Marigold. I had never opened one. But Daniel had apparently been planning to use it against me. The question was, what exactly was the Marigold account? And how had my husband intended to weaponize it? I left Meg's office knowing that whatever came next, there was no longer any possibility of retreat. We had crossed a line, not through any dramatic action, but through the simple, patient act of looking closely at the truth. The truth had looked back, and it was far worse than I had imagined. The Marigold account turned out to be a brokerage account that Daniel had opened in my name without my knowledge. Gerald Park found it in 10 days. A taxable investment account at a regional brokerage firm in Schaumburg, opened with a forged signature 14 months earlier, funded with $47,000 transferred from an LLC that Daniel had established 6 months after my father's death. The account held shares of 3 companies. Its quarterly statements had been sent to a P.O. box in Evanston. The account was registered under my Social Security number. I sat in Meg's conference room and looked at the account registration document with my forged signature at the bottom. And I felt something very specific. Not rage, not grief, not even fear. What I felt was clarity. The clean, hard-edged clarity of a situation that is finally resolved into its true shape. Daniel had created a fake account in my name. He had used it, or intended to use it, to argue that I had moved inherited funds into a jointly accessible vehicle, blurring the line between the trust and our marital estate. The Naperville meeting referenced in his email to Walsh had been a meeting with my father's trust officer, which Daniel had attended and during which he had asked, apparently quite specifically, about the conditions under which trust assets could be reclassified. He had been researching the legal vulnerabilities of my inheritance while sitting in the same room as the man who had built it. My father had been alive for that meeting. He had died 3 months later. I took a long breath and told Meg to proceed with everything. We filed a motion for sanctions based on the forged signature. We filed a dissipation claim for the $214,000 in transferred marital assets. We submitted the email chain as evidence of premeditated fraudulent intent, and we prepared our central defense, a complete documentation of the trust's history, its establishment, its management, its complete separation from our marital finances, supported by bank records, trust statements, and an affidavit from the trust officer at the Naperville firm who had managed my father's estate. Meg also retained a forensic document examiner who confirmed within 72 hours that the signature on the Marigold account registration was not mine. The response from Daniel's camp came on a Thursday morning, and it did not come through the court. It came through my personal cell phone. Daniel called at 7 a.m. I was in my car in the parking garage beneath my office building. I answered because I recognized the number, and I had decided some weeks earlier that I would not give him the satisfaction of watching me avoid him. "You've made a very serious mistake." His voice was different from the last time we'd spoken. The smoothness was gone. What was underneath it was harder and less controlled. "You don't want to push this. You really don't. Daniel, I have documentation that you knew about the Marigold account, that you were copied on the opening correspondence." His voice tightened. "We can produce it. You'll look like you're lying. You'll look like you hid assets and then tried to blame me." I looked at the concrete pillar in front of my car. I thought about forged signatures and P.O. boxes, and a man sitting at my father's trust officer's table, quietly taking notes, 2 months before my father died. "Then produce it," I said. A long pause. "Claire, think about what you're doing. You're a successful woman. You have a career. You have a reputation. This gets ugly. It gets public. Is that what you want? For people to read about your finances in the Tribune? For your colleagues to—" "Goodbye, Daniel." I hung up. I sat in the parking garage for approximately 90 seconds. Then I took out my phone again and called Meg's direct line. "He just called me," I said. "He claimed he has documentation showing I knew about the Marigold account. He also implied a threat to my professional reputation." I heard Meg click her pen. "We'll file for a communication order. All contact goes through counsel, effective immediately." Another click. And Claire, what he just did, threatening reputational harm in connection with the litigation, that's relevant. Don't delete the call log. That afternoon, Walsh called Meg directly. The conversation, which Meg relayed to me with her customary economy of expression, lasted 20 minutes. Walsh proposed a settlement. Daniel would drop the inheritance claim entirely in exchange for the withdrawal of the fraud allegations and a 50-50 split of the marital estate. Meg told him we'd consider it. She then called me and said, "We're not accepting that, but I want them to think we are for 2 weeks." I understood. 2 weeks to finish building the case, 2 weeks to let them believe we were wavering. But the calls didn't stop with Daniel. On a Saturday afternoon, I was at my kitchen table reviewing documents when my doorbell rang. I opened the door to find a woman I had seen exactly once before, at a distance, across a restaurant, on a Tuesday in Wilmette. She was perhaps 34, expensively dressed, with the specific kind of confidence that comes from a person who has never been the one on the losing side of a situation. Her name was Vanessa Holt. She did not introduce herself. I recognized her from the photograph my investigator had included in the asset report. "May I come in?" she asked. "No," I said. She didn't blink. "Claire, I think you and I should talk. Woman to woman, without attorneys." She leaned slightly forward. "Daniel is going to win this. You know that. The Marigold account. There are emails. There are communications you haven't seen yet. You should consider what it would cost you to keep fighting." I looked at her for a moment. She was standing on my front porch in Oak Park in the November cold, trying to tell me to surrender. "Vanessa," I said, "the next time you come to my home, I'll have it documented as harassment." I closed the door. I stood in my hallway for a moment, back against the door. My heart was moving a little faster than I would have liked. I won't pretend there was no fear, there was. The fear was real. But what I noticed, beneath the fear, was something else. A heat, a steadiness, a sense of my own position that did not shift. I booked 3 days off work the following week. I drove to my brother Todd's house in Madison. I sat on his couch and watched football and ate his wife's chili and slept 9 hours a night for 3 nights in a row. I came back to Chicago rested and ready. The offer came through Walsh the Monday after I returned from Madison. It was considerably more generous than the first one. Daniel was now willing to drop the inheritance claim, accept a 40-60 split of the marital estate in my favor, and make no public statements about the Marigold account or any associated allegations. If I withdrew the fraud filing and signed a mutual non-disparagement agreement within 10 days. Meg laid out the terms on her desk and watched my face. I read the document carefully, then I set it down. "He's scared," I said. "Yes?" "How scared?" She allowed herself a small, precise smile. Walsh used the phrase pragmatic resolution 4 times in our conversation. In my experience, that phrase appears in direct proportion to how badly opposing counsel wants to exit a situation. I thought about what a 40-60 split would mean in practical terms. It would mean walking away with the inheritance intact and a slightly larger share of the marital assets than a straight division would yield. It would be, by any objective measure, a good outcome. It would also mean that Daniel paid no real price, no fraud finding, no public record, no accountability for the forged signature, the hidden accounts, the phone calls, the woman on my doorstep. I looked out the window at the lake, gray and flat in the December light. "No," I said. Meg nodded once, as though she had anticipated this. "Then we proceed." What happened in the following 2 weeks was a specific kind of silence, the silence of 2 sides watching each other, each waiting to see who would move first. I went to my office. I worked on a mixed-use development project in Evanston, reviewing load-bearing specifications and arguing pleasantly with a structural engineer about cantilever ratios. I had lunch with clients. I answered emails. I live my life with the disciplined normalcy of someone who refuses to let a crisis redefine their daily existence. But I was watching. Walsh filed 2 motions in that period, both procedural, both designed to slow the discovery process. Meg countered both. The court denied one and partially granted the other, pushing our timeline back by 11 days. It was a minor irritation, not a setback. And then Vanessa tried again. Not at my door this time. She sent a message through a mutual acquaintance, a woman named Priya, who called me with obvious discomfort to relay a request for coffee, just to clear the air. I declined through Priya with politeness and no explanation. That same week, an anonymous source sent my firm's managing partner an email suggesting I had been involved in financial irregularities in connection with an estate dispute. The email was vague, sourced to nothing, and my managing partner, a practical, skeptical man named Howard Ellison, forwarded it to me with a single line. "Looks like nonsense." "Ignore?" I replied. "Please keep it on file. It may be relevant to ongoing legal proceedings." Howard responded, "Got it. Let me know if you need anything." That mattered more to me than I expected. I remember looking at that 3-word response, "Let me know," and feeling something ease slightly in my chest. Not everyone was waiting for me to fail. It was Sarah Kellerman who gave me the most important support, though she didn't know it at the time. We had dinner in mid-December at a small Italian place in Wicker Park. Just the two of us, a bottle of Barolo and a corner table far enough from the bar that we could hear each other. Sarah had been worried about me since the summer. She had, after all, been the one to tell me about Spiaggia, and I knew she carried some guilt about that, as though the act of delivering news had made her somehow responsible for it. I told her where things stood, not all of it, not the Marigold account or the fraud filing, but enough. I told her that it was harder than I had expected, that there were days when the easiest thing would be to simply accept whatever settlement made him go away. She poured more wine and looked at me with the directness she had always had, even in graduate school. "Claire," she said, "do you remember your father?" "Of course." "Do you remember what he always said? About the trucks?" I did remember. My father had started with 2 trucks, a brother-in-law's loan, and a contract from a regional grocery chain. When things were hard in the early years, when the margins were thin and the equipment kept breaking, he used to say, "The only people who stay broke are the ones who stop believing they deserve to be paid what they're owed." I sat with that for a moment. "He earned that inheritance," Sarah said quietly. "He earned it so you wouldn't have to be afraid of men like Daniel. That's why he set up the trust the way he did." I looked at my wine glass. She was right. My father had been meticulous about the trust, not out of coldness, not out of distrust of Daniel specifically, but because he was a man who understood that protection built in advance is the only kind that holds. He had protected me before he died. Now I needed to honor that. I drove home from Wicker Park in the December dark, along Lakeshore Drive with the water black and vast to my left, and I felt, for the first time since the summons had landed on my office desk, genuinely calm. Not the brittle, performed calm of someone suppressing fear, the real kind, the kind that comes from knowing exactly what you're doing and why. Daniel was watching and waiting. I let him watch. Daniel came to my house on a Sunday afternoon in January. He did not call first. He did not message through counsel as the communication order required. He simply appeared at my front door at 2 p.m, wearing the charcoal pea coat I had given him for Christmas 4 years earlier, holding nothing. No briefcase, no folder, just his hands in his pockets and an expression I recognized from 11 years of marriage. The look he wore when he was about to be reasonable. I stood in my doorway and said nothing. "I'm not here as your adversary," he said. "I'm here as someone who spent 11 years of his life with you and who thinks we've both let this get out of hand." "You're violating the communication order," I said. "Claire, which means this conversation is being documented. Whatever you say, I'm going to tell my attorney you were here. I'd suggest you think about that." He shifted slightly. The reasonableness in his expression recalibrated, not disappearing, but adjusting, the way light adjusts through a lens. He was very good at this. He always had been. "I want to talk about the fraud allegation," he said, "because what you're doing, what your attorney is doing, is going to hurt us both. This has escalated past what either of us intended. There are ways to step back from this. I'm willing to be very generous, Claire. The Marigold account. I can explain all of that. It was a mistake in filing. The brokerage associate miscategorized the account holder. I have the documentation. Ah, there it was. So now the forged signature was a brokerage associate's clerical error. The account opened in my name, funded by a Shell LLC. Statements routed to a P.O. box. All of it reducible, in this retelling, to a paperwork misunderstanding. I looked at him on my doorstep in the cold January light. This man I had shared a bed with for 11 years, and I tried to locate whatever affection I had once had for him. I found only the clean, flat recognition of his pattern, the charm, the plausible explanation, the pivot to reasonableness when force had failed. "Daniel," I said, "go home. If you pursue the fraud claim, you'll be deposed. Your finances will be fully public record. Your firm." "My firm knows. My managing partner has been informed. There is nothing you can reveal that would damage me, because I've already disclosed everything voluntarily." I held his gaze. "Can you say the same?" The reasonableness dropped. It didn't drop all at once. It unraveled, incrementally, across about 4 seconds. His jaw shifted. Something tightened around his eyes. The man I had watched perform calm for 11 years was now, very slightly, performing rage. "You are making a catastrophic mistake," he said. Quietly, precisely. "I have resources you don't know about. Walsh has contacts in the financial press. This story, your father's trust, the dispute, the accusations you've made against me, it can be framed in ways that follow you for years. Do you understand what I'm telling you?" "I understand perfectly," I said. "Goodbye, Daniel." I closed the door. I stood in my hallway with my back against the door and listened to his footsteps on the porch, and then the sound of his car starting and pulling away down the street. I was shaking, not visibly. If you'd been standing across the room, you wouldn't have seen it. But my hands, pressed flat against the door behind me, were trembling slightly. He had just threatened me with a press campaign, with reputational damage, with a version of my father's estate printed in the financial press and framed to look like a grasping woman protecting ill-gotten wealth. Was it a real threat? Could Walsh actually do that? I stood there for a full minute, pressing my palms against the door, breathing slowly. And then I thought, he came here. He had violated the communication order, driven to my house, stood on my porch, and personally delivered a threat. That meant the official channels were no longer working for him. The settlement offers had failed. The anonymous email to Howard had failed. Vanessa's visit had failed. And now he was here, in person, because he was running out of moves. The shake in my hands didn't stop, but it changed. It was no longer pure fear. It was something more complicated. The adrenaline of recognizing that you are ahead and that your opponent knows it. I called Meg at 2:23 that afternoon. She listened to my account of the visit without interrupting. When I finished, she was quiet for precisely 5 seconds. "He violated the communication order," she said. "We're filing a contempt motion tomorrow morning, and the press threat—" She paused. "That's going to be very useful to us, Claire." "How?" "Because it's an admission that he's considering a strategy to influence the proceedings through public pressure. Documented threat of media interference in active litigation." Another pause, and I could hear her selecting her words with the care of someone who knows the difference between satisfaction and professionalism. Judges find that interesting. I hung up and stood at my kitchen window for a long time, watching the backyard in the January gray. The garden was bare. The oak tree my father had helped me plant. The first summer we owned the house stood at the far corner of the yard, leafless, its branches precise and still against the white sky. He had come to my house. He had threatened me. He had stood on my porch and offered me a clean exit, and when I declined, he had shown me exactly what he was made of. I was afraid. I am not going to pretend otherwise. But I was more resolved than I had been at any point since the summons, because a man who resorts to threats is a man who has run out of arguments, and we were 3 weeks from the hearing date. The hearing was scheduled for a Thursday in late January in a courtroom on the 4th floor of the Daily Center. I wore a charcoal blazer and gray trousers. Meg wore navy. We arrived 40 minutes early. By the time Daniel and Walsh took their seats at the opposing table, I had been sitting in that courtroom long enough to feel familiar with the light coming through the tall windows and the particular acoustics of the room. Judge Patricia Okafor had been on the bench for 18 years, a woman with a reputation for patience and procedure and no tolerance for gamesmanship. Walsh opened for Daniel's side. He was polished. He laid out the inheritance claim with structured clarity. 11 years of marriage, significant contributions to household stability, a wife who had been free to manage a substantial inherited estate because of the domestic stability her husband had provided. He was careful not to mention the Marigold account directly, anchoring the commingling argument around the Naperville meeting and Daniel's purported consultation with my father's trust officer. I listened to all of it without moving. Then Walsh introduced his evidence. And here is where things began to come apart. The first document he submitted was an email, purportedly from me to Daniel discussing the account and referencing the Naperville arrangements. Walsh argued this demonstrated my knowing participation in the financial structuring he'd described. Judge Okafor examined it. Then she looked at Meg. Meg stood. Your Honor, we retained a forensic document examiner, report already in evidence as Exhibit 14, who analyzed the metadata of that email. The document was created 11 months after its stated date on a device registered to Daniel Morrison's Consulting, LLC. The email address in the header does not match Ms. Harrison's actual server logs, which we've also submitted in full. She paused. The document is fabricated. The courtroom was very quiet. Walsh was on his feet immediately. Your Honor, we have the original. Which device produced it? Judge Okafor asked. Directly to Walsh. Not to the room. Walsh said something to Daniel in a low voice. Daniel said something back. The exchange lasted approximately 8 seconds, which is a very long time when a judge is watching you. We'll need to verify the sourcing, Walsh said. Judge Okafor wrote something on her notepad. Continue, Ms. Chen. Meg continued. She submitted the forensic accounting report. The $214,000 in dissipated marital assets, traced transfer by transfer to an LLC, to a Lincoln Park brokerage account, to Vanessa Holt. She submitted the Marigold account documentation, the forged signature, the account registered under my Social Security number, the P.O. box in Evanston, the funding transfers from the LLC. She submitted the contempt motion documentation covering Daniel's January visit to my home and his press threat, and then she submitted the trust documents. The complete history of my father's trust, established 3 years before his death, structured expressly as separate property, managed in a fully segregated account at the Naperville wealth management firm, with 0 transfers into any joint marital account across the entire marriage. The trust officer had submitted an affidavit. The wealth management firm had submitted statements going back to the trust's inception, There had been no commingling. Daniel had attended one meeting and asked questions. The trust officer's affidavit stated plainly that he had provided no advice to Daniel Morrison, and had noted afterward in an internal memo now submitted as Exhibit 31 that Daniel's questions had seemed oriented toward identifying weaknesses in the trust's separation rather than managing the asset constructively. My father's trust officer had written that in 2022. He had been watching out for me before I knew I needed watching out for. Walsh attempted to recover. The forged email became a labeling error. The Marigold account became a miscommunication with a brokerage associate. Daniel's visit to my home became a good faith attempt at private resolution. Judge Okafor listened to all of it. Then she looked at Daniel directly, not at Walsh, at Daniel, and asked him one question. Mr. Morrison, are you aware of the forensic finding regarding the email you submitted as evidence? Something happened to Daniel's composure in that moment. It didn't collapse. It flickered. His eyes moved to Walsh and back. My attorney can address. I'm asking you, Judge Okafor said, quietly. Absolutely. I was not aware of any forensic concern, Daniel said. You submitted a document as evidence in this proceeding that your own device's metadata indicates was created after its stated date. She looked at him for 3 full seconds. We'll address the consequences of that separately. Walsh's hands were very still on the table in front of him. I said nothing. I kept my eyes forward. I had prepared for this moment with the same discipline I had brought to every other part of this process, not with triumph, but with the steady certainty of someone who has done the work and trusts it. But I will tell you what I felt. I felt my father in the room. I felt the 40 years of 2 trucks in 8 states. I felt the trust document he had signed to protect me from exactly this kind of man. The hearing ran for another 2 hours. By the end, Walsh had moved to withdraw 2 of his 3 primary exhibits. The fraud allegation was formally referred for separate investigation. The commingling claim, stripped of its fabricated evidence, rested on nothing. We walked out of the Daily Center at 4:15 into the January cold. Meg buttoned her coat and looked at me. He'll try to settle again. I know. What do you want to do? I looked out at Randolph Street, at the city moving in the early winter dark. I want the ruling, I said. I want it on record. Meg nodded. She almost smiled. Then that's what we'll get. Judge Okafor issued her ruling on a Tuesday morning in February. I read it at my kitchen table with a cup of coffee going cold beside me. 31 pages. I read all of them. On the central question, the ruling was unambiguous. The trust had been properly established as separate property, independent of the marriage. There had been no commingling. Daniel Morrison's claim to any portion of the $18 million inheritance was denied in its entirety. On dissipation, the full $214,000 was ordered returned to the marital estate. The split would be 65/35 in my favor, in recognition of Daniel's documented financial misconduct. On the Marigold account and the fabricated email, her language was direct. She referred the matter to the Cook County State's attorney for potential criminal charges. She referred Walsh to the ARDC. She sanctioned Daniel for the communication order violation and ordered him to pay 60% of my legal fees. He appealed. It was dismissed 4 months later, citing serious concerns regarding the integrity of evidence submitted by the appellant. Walsh received disciplinary probation. Daniel was charged with felony financial identity fraud and plea negotiated his way to 2 years of supervised probation and full restitution. No prison. I want to be honest about that. but his business collapsed. His clients left, not through any campaign, simply because businesses don't retain consultants named in rulings involving fabricated evidence. He moved to Phoenix. Vanessa was gone within 3 months of the ruling. The inheritance remained exactly where my father had placed it, untouched, undivided, wholly mine. Todd texted at 9:15 that morning. Dad was right to set it up the way he did. So proud of you. I read it 3 times, put the phone down, cried for 5 minutes. Not grief, not quite relief, but the particular exhaustion of a fight that is finally, completely over. Then I washed my face and made a fresh cup of coffee. The document Meg laid on that table was not dramatic. It was simply my father's trust instrument, prepared 3 years before his death, signed with the foresight of a man who understood exactly what the world contained. Daniel had built his entire case on the assumption that I'd be too afraid to use it. In 4 seconds of courtroom silence, I watched him understand how wrong he had been. "You're going to lose this one," he had told me. I had smiled. He had laughed. I let that laugh go somewhere on the Eisenhower near the Harlem Avenue exit in the ordinary afternoon light of a city that never stopped moving while I was rebuilding my life. 6 months after the ruling, I sold the house in Oak Park. I bought a condominium near Lincoln Park, 19th floor, west-facing windows that turned gold by 5 o'clock. I liked the space. I liked belonging to myself again. I was promoted to principal that spring. I started running again, 3 mornings a week along the lakefront, 8 miles on Saturdays. I built the habit back slowly, the way you rebuild anything a bad season took from you. Daniel's business dissolved within 14 months. The felony charge followed him in every professional search. He moved to Phoenix. Vanessa was long gone. Walsh practiced more carefully, with a permanently marked record. I don't think about any of them much. That, more than anything, is the real victory. Not the ruling, not the money, not the trust preserved intact. It's the morning runs, the gold light through west-facing windows. My father built his protection quietly, years before it was needed. The best thing I could do to honor him was to live well. I am doing exactly that. My father used to say, "The best walls are the ones you build before you need them." He was right. The trust he built didn't just protect my inheritance, it protected my dignity and my future. If I learned one thing from all of this, it's that fear is not the enemy. Fear tells you what matters. The enemy is letting fear make your decisions. Daniel laughed. I smiled. And I built my wall, one document at a time. So I have to ask you, if someone tried to take what your family spent a lifetime building, would you settle or would you fight? Leave your answer in the comments. If this story stayed with you, share it. Someone out there might need to hear it. Thank you for being here.